The International Criminal Court is now in session.
Good afternoon, everybody. The court is here today to hear the arguments in case the prosecutor versus Lord Blaze. And if the parties are ready, I would like to ask the teams to present themselves and then to start the pleading. Prosecution, please.
Good afternoon, Mr. President, Your Honors, and may it please the court. My name is Moramai Koman, and I'll be representing the prosecution in the case against Lord Blaze. I will be speaking for 13 minutes. My co-counsel will be speaking for the remaining 12.
Thank you very much. And the defense, please.
Good afternoon, Mr. President, Your Honors. My name is Yuri Wen, and this is a great honor for me and for my co-counsel, Mr. Olivier, to appear before this court as a defense.
Thank you very much. And if the prosecution is ready, the prosecution, you have a floor.
Good afternoon again, Mr. President, Your Honors, and may it please the court. The prosecution submits 4 claims. I will first argue that this case falls within the jurisdiction of the court and that the case is admissible. My colleague will then assess the interest of justice and the individual criminal responsibility of Lord Blaze for the enslavement of at least 30,000 earthbowers. In relation to the first claim, it is clear that both the temporal jurisdiction and the territorial jurisdiction have been fulfilled, and we will therefore only focus on the subject matter jurisdiction. Within this, I will make 2 submissions one on the contextual elements and a second on the material elements. Turning to the contextual elements, for a conduct to constitute a crime against humanity, there needs to be a widespread or systematic attack directed against a civilian population pursuant to a state policy or an organizational policy. A systematic attack is when the attack is organized or occurs in a regular pattern, as stated in the ongoing trial judgment, paragraph 2682. Furthermore, there's a state policy when the attack is planned, organized, or directed, as stated in the route to confirmation of charges, paragraph 210. Your Honors, the Earthbound population have been the target of 4 years of oppression by the Fiery Republic government. This started in 2015 by forbidding all Earthbound rituals and ceremonies, as can be seen in case facts, paragraph number 4. It only escalated from there in 2018, where all public gatherings of Earthbowers were violently disbanded. Ultimately, Lord Blaze enacted the Anti-Extremism Executive Order, which ordered the monitoring of the situation in Black Mound and stopping all apparent threats in the name of national security. This led to the opening of 40 detention centers throughout the Fiery Republic, among which Center Rig was the biggest. Your Honors, entire Earthbower families were sent to these detention centers where they were forced to work on building and repairing cars. It is clear that a systematic attack specifically targeting the Earthbound population took place within the Fiery Republic. Turning to the second argument, the conduct clearly constitutes the crime against humanity of enslavement pursuant to Article 7(1)(c) of the statute. The detainees were subject to various forms of coercion and oppression even before they were held in detention, and this only intensified within Center Rig. Your Honors, the fact of detention without due process itself clearly shows the presence of coercion. The Earthbound detainees experienced the control of physical environments, which is an indication of enslavement, as stated in the ongoing trial judgment, paragraph 2712. In this case, the Earthbowers were sent to these detention centers without a trial or a conviction. They were not told the reason of their detention, nor its length. Their passports were confiscated upon their arrival and not returned to them upon their release, And furthermore, they were held in a heavily guarded island fortress surrounded by security walls and surveillance, as can be seen in case facts, paragraph number 14. Your honors, not only were the detainees held in detention, but within this detention center, they were also forced to work. They were subject to forced labor. Forced labor, or the threat or use of force, can constitute enslavement, as stated in the ongoing trial judgment, paragraph 2712. Forced labor is all work or service which is exacted from any person under the menace of penalty and which said person has not offered himself voluntarily, as stated in Article 2 of the Convention of Forced Labor. Your honors, the work performed by the detainees was involuntary. They did not consent to this work. And even if they did, this consent was rendered irrelevant. Consent is rendered irrelevant when the individual is held in detention or captivity and there's a threat or use of force and other forms of coercion, such as fear of violence, as was stated in the Kunarach trial judgment, paragraph 542. Your honors, obtaining consent from the Earthbound detainees became impossible in this case. Their environment was so coercive as to negate this. Generally, they were prohibited from exercising their rituals within the detention center and prohibited from speaking their own language, as can be seen in case facts, paragraph number 13. And more specifically, they lived in a constant fear of violence. They had to work every day of the week with barely any breaks under the menace of penalty. If they refused to work or were unable to work, they would be cruelly punished. They will be separated from the group, put outside in freezing temperatures all day, where they were deprived of food and water. Your honors, the deprivation of liberty, control of physical environment, and the forced labor together reach the threshold of enslavement. And the conduct clearly constitutes the crime against humanity of enslavement. I will now turn to my second claim of admissibility, where the prosecution submits three.
Sorry. Yes, if the presiding judge allows me, I would like to make a question in relation to the point that you mentioned of the crime against humanity of enslavement. You were mentioning different facts in relation to the condition of enslavement, and this bench would like to know what is the evidence that is available in this specific case, and if that evidence is valid, of course, to be used in this court, and if there's a kind of corroboration evidence that you can also mention. Thanks.
Your Honor, the evidence used in this case is the statement of Hyeyoung to prove the conditions of menace of penalty in the center rig. It was corroborated by the statements by the family members, as can be seen in case facts paragraph number 13, which also stated the conditions of the detention center, such as the holding of the passports and the reason of detention being told to the detainees or not. Furthermore, we have an aerial footage, as can be seen in case facts paragraph number 13, which show the environment of the center and the island which the center is on.
But Consul, sorry, but there's a kind of contradiction between some of the statements from Hyeyoung in relation that they didn't know that, for example, the companies that can be involved in relation to the forced enslavement. The footage mentioned some of these issues, and then there's an issue that you mentioned in terms of the family members and the hearsay evidence. So is that enough in terms of the standard of proof for this procedural moment before this court?
Yes, Your Honor, we do believe that this evidence is enough to reach these probative value in this case. Furthermore, the disconnect of certain facts, and such as the statement by Hyeyoung that he could not see what automobile company was taking place, this is not necessarily relevant to prove the conditions of the prison. And therefore, we still believe that this evidence is enough.
Counsel, before you proceed, I would like to turn back to the contextual elements of the crimes against humanity. In this case, we have only one count of indignant enslavement. And turning back to these contextual elements, is it relevant to refer to the whole policy of the Fire Republic against the East borders since 2015, having in mind that our case took place only later?
Yes, Your Honor, this policy is there to show the attack that was going on against the Earth Hour civilian population. As to show an attack, there needs to be a conduct involving multiple commissions of acts. And this state policy is here to prove that such an attack took place. And this attack also includes the enslavement.
You may proceed.
I will now turn to our second claim of admissibility. Here, the prosecution submits 3 arguments. First, the case has not been tried by another court pursuant to Article 17(1)(c), read together with Article 20, subsection 3. In the Gaddafi admissibility challenge, paragraphs 36 and 38, 2 requirements were set. 1, there needs to be a final judgment, and 2, a verdict on the merits, meaning a decision on conviction or acquittal. In the case of Lord Blaze, the decision given by the national judge does not decide on the merits. It's only deciding on the conditions set by law number 14. Law number 14 only includes a public apology to the victims and the disarmament of the AANG members. The court does not assess Lord Blaze's criminal actions, and therefore it does not lead to a conviction or an acquittal, and Lord Blaze may still be tried before this court. Your Honors, amnesties may not be invoked, as amnesties are 1, for the purpose of shielding, and 2, prohibited under customary international law. We submit 2 arguments within this. First, the ruling given by the national judge was for the purpose of shielding Lord Blaze, and he may therefore still be tried in accordance with Article 20, paragraph 3, subsection A. Amnesties by their very nature are for the purpose of shielding, as was stated in various cases, such as the Barrios Altos versus Peru case in paragraph 41. Furthermore, Your Honors, Lord Blaze specifically sought out the amnesty to protect himself from any further criminal prosecution, as can be seen in case facts, paragraph number 23. Finally, amnesties are prohibited under customary international law for grave crimes, including crimes against humanity. There's a wealth of case law that confirm this. For example, the Gaddafi...
Sorry, Consul, what is the authoritative source for this course in using customary law? Where it's that mentioned?
Yes, Your Honor, there's a wealth of case law that confirm this, such as the Gaddafi admissibility challenge in paragraph 61 states that there's a strong, growing universal...
In particular, I'm referring to the Rome Statute, if it's mentioned the source of customary law.
Your Honor, do you mean the fact that the court may apply customary law? Yes. Your Honor, according to Article 21, 1B of the Rome Statute, the court may apply customary international law. And in this case, there is a wealth of case law.
And what does constitute customary international law?
Your Honor, customary international is a general practice of states accepted as law. There are 2 elements, namely state practice, which must be consistent and virtually uniform, and opinio juris.
Could you please briefly refer to state practice and opinio juris regarding this point? Briefly.
Yes, Your Honor, there's a consistent application of the belief that amnesties are prohibited under customary international law for grave crimes, as this was consistently applied by various courts, such as the Special Court for Sierra Leone, the extraordinary chambers in the courts of Cambodia, and the Inter-American Courts of Human Rights. This shows a consistent application of the prohibition of amnesties for grave crimes. Your Honors, as a state...
and opinio juris?
Yes, Your Honor. This also proves the belief that this indicates the belief that this practice is required by law for states.
You may proceed.
Your Honors, it was stated in the preamble in paragraph 5 of the Rome Statute that the Rome Statute is determined to put an end to impunity. Accepting the amnesty granted to Lord Blaze would lead to impunity of the crime against humanity of enslavement, and therefore, this amnesty may not be invoked before this court. This concludes the first two submissions of the prosecution. My colleague will now continue with the final two.
Mr. President, Your Honors, good afternoon and may it please the court. My name is Anna Wischermann, and on behalf of the prosecution, I will address our third and fourth claim. I will first prove that the Chamber may not dismiss the case against Lord Blaze on the basis of an assessment of the interests of justice. And secondly, that there are reasonable grounds to believe that Lord Blaze is individually, criminally responsible as a superior. In relation to our third claim on the interest of justice, the prosecution's argument rests on two grounds. One, that the Chamber does not have the competence to review the decision of the prosecutor under Article 53(3)(b), and two, that there's no indication that proceedings against Lord Blaze would not serve the interests of justice. In relation to the first of these two, the prosecution of course acknowledges the supervisory function of the pretrial chamber. In relation to the interest of justice, however, this function is clearly limited under Article 53(3)(b) to review of negative decisions of the prosecutor, meaning decisions not to proceed with an investigation or prosecution. This was confirmed by this court in the situation in the Democratic Republic of Congo on pages 4 and 5, and the situation in Kenya, paragraph 63. In the case at hand, the prosecutor has issued a positive decision to investigate and prosecute Lord Blaze. There is no negative decision for the Chamber to review, and there is accordingly no basis for the Chamber to exercise its power under Article 53(3)(b). Should the Chamber nonetheless find that it has the power to review, it should find that there are no indications that the case against Lord Blaze would not serve the interest of justice. Here, the prosecution wants to firstly reiterate that the assessment of the interest of justice is a negative assessment. The prosecutor shall proceed unless there are indications that doing so would not be in the interest of justice. The prosecutor therefore has no obligation to affirmatively determine that a case would serve the interest of justice. This becomes evident from a plain reading of the provision in Article 53 and was also confirmed by the appeals chamber of this court in the situation in Afghanistan, paragraph 49. Considering the stage of proceedings, it is reasonable to assume that the prosecutor has already assessed the interest of justice criterion and came to the conclusion that there are no indications that proceedings against Lord Blaze would not serve the interest of justice, based on the factors set out in Article 53. Those factors include the gravity of the crime, the interests of the victims, and the role of Lord Blaze in the crime. Your Honors, in this case, the gravity requirement is clearly fulfilled. We are dealing with a large-scale, systematic, and violent attack against the Earthbowers. 40 detention centers were opened throughout the Fire Republic, and at least 30,000 Earthbowers were enslaved in Centuric alone. As for the interests of the victims, there are no clear facts indicating the interests of the victims. However, once again, the prosecution wants to stress that the assessment of the interest of justice is formulated in the negative, as there are no clear indications that the victims would oppose the prosecution of Lord Blaze. This chamber shall proceed with the prosecution. As for the role of Lord Blaze in the crime, Your Honors, as a superior, Lord Blaze failed to fulfill his duties as a superior. Within my next claim, I will further explain the role that Lord Blaze played as a superior. However, his role in the crime extended beyond the failure to fulfill his duties. Lord Blaze initiated, facilitated, and oversaw the enslavement in Centuric. Based on these factors, Your Honors, it is clear that the case against Lord Blaze would serve the interest of justice. And should the pretrial chamber review this consideration, it should come to the same conclusion. Moving on to our final claim on criminal responsibility. Your Honors, as a superior of the BNS agents and Ursa Azila, Lord Blaze played an integral part in the crime. I will prove that all 4 requirements under Article 28b are fulfilled. Firstly, the prosecution submits that Lord Blaze held a position of effective authority and control over the subordinates. 2 factors that can be used to prove effective authority and control are the official position of the suspect and his power to issue and give orders, according to Bemba Confirmation of Charges, paragraph 417. As President of the Fire Republic, Lord Blaze held the highest official position within the country. Through this position, he had the power to issue the anti-extremism executive order. He also had the power to give orders directly to the Minister of Interior, Ursa Azila, and the BNS agents. Several examples where Lord Blaze made use of his power can be seen in Exhibit 1 and Case Facts paragraph 17. In Exhibit 1, we see that Lord Blaze was the one that ordered and controlled the movement of 10,000 prisoners to different centers. And it was also Lord Blaze who ordered the release of detainees. In Case Facts paragraph 17, we see that Lord Blaze ordered the BNS agents directly to end the conflict and start peace negotiations.
Excuse me, Counsel. I have a question in relation to this point, because I would say that you are quoting the decision in the case of Bemba, which refers to military superiors. In this particular case, we are in a different scenario, which is civilian superiority. So in this particular case, what would be the application of those standards to this specific case? And what would be the difference between the military superior and the civil superior in terms of like stretching the responsibility to the highest person with the president when there's a kind of delegation that is admitted within the public administration? And in relation to the point that you're referring, the measure that he took of about moving some detainees to other place, I would say that this could be a measure to avoid any kind of overcrowding or situation that can be more complicated. I don't, in my personal, or at least how you are presenting the facts, I don't see that that is something negative, because he was saying that was to avoid any future problem. Thanks.
Your Honor, the standard of effective authority and control is the same for military and civilian superiors. This follows from the fact that the wording in both Article 28A and Article 28B is the same. Of course, the factors that can be used to prove this might vary between the two. However, in this case, the fact that Lord Blaze clearly had the power to order the BNS agents and Ursa Azila indicates that he did possess this effective authority and control. And Your Honor, the intention that Lord Blaze had by maybe moving around the prisoners is irrelevant when assessing whether he had effective authority and control. The fact that he had this power is what is the crucial element to assess in this case, and not what was his intention behind the order. Turning to the second requirement, this court established in Bemba Confirmation of Charges, paragraph 426, that the failure of the suspect to exercise his duties as a superior must have increased the risk of the commission of the crime. Your Honor, Lord Blaze played a crucial role in the commission of the crime. The power afforded to Ursa Azila by Lord Blaze not only increased the risk of the commission of the crime, but constituted the basis which made the commission possible. Additionally, Lord Blaze increased the risk of the commission of the crime by providing the materials that were used to exact forced labor on the detainees, and this can be seen in Exhibit 2. Moving on to the third requirement, the mental element. This court has established in the Bemba trial judgment, paragraph 191, that the suspect must have known that his subordinates were about to commit or were committing the crime to fulfill the mens rea standard under Article 28b. And here, Your Honours, there are several factors which clearly prove that Lord Blaze fulfills this standard. Firstly, there existed an organized structure with an established reporting system between Lord Blaze and his subordinate Ursa Azila. Reports were being submitted by Ursa Azila every 6 months directly to Lord Blaze. And all of those reports were submitted, Your Honours, as can be seen in clarification to the case facts number 2. Additionally, communication between the two took place via phone, as can be seen in Exhibit 1. And during the call, Lord Blaze and Ursa Azila discussed specifically the situation, transporting, and holding of detainees in Center Rig. There are reasonable grounds to believe that Lord Blaze knew about the enslavement. Turning to our fourth and last submission, Lord Blaze failed to exercise his duties as a superior. Your Honours, Lord Blaze had the duty to prevent, repress, and submit the matter to the competent authority, and yet he failed to fulfill any of those duties. The prosecution therefore submits that Lord Blaze is individually criminally responsible under Article 28b. Unless I may be of further assistance, this concludes the submissions of the prosecution.
Thank you very much, counsel. And we now turn to the defense. And the defense team, you have a floor.
Mr. President, Your Honours, today we're standing here on behalf of the defense of Lord Blaze, a man who fulfilled his sole duty to establish and maintain peace in the Far Republic, a state of 25 ethnic groups aiming to live in harmony.
Counsel, before you proceed, just one brief clarification. Could you please specify who are you, because you are both on the screen?
Your Honor, my name is Hyeyoung Lee, and the defense will now address the issues before the court.
Thank you very much. I'm sorry.
And now, unlawfully, today, Lord Blaze stands here for the alleged and horrible crime of enslavement, in the commission of which he lacks any role. Respectfully, Your Honors, during the next 17 minutes, I'll address the following 3 issues. Firstly, the case against Lord Blaze does not fall within the subject matter jurisdiction of the court. Second, the case is inadmissible. And thirdly, it would not serve the interest of justice. And the remaining 8 minutes will be used by my co-counsel, Mitchell Lefier, who will address the final issue concerning the irresponsibility of Mr. Blaze. Now, Your Honors, with your permission and regard, the defense will move to the first issue before the ICC. Although the prosecution contested the mainly contextual elements of the alleged crime of enslavement, the defense will address the following 2 elements, the mental and the material, and prove the absence of such elements. With regard to the first argument, we submit that the material element of the alleged crime of enslavement is absent in the case at hand. Your Honors, under Article 7, Clause 1c of the elements of crime, the exercise of powers attaching to the rights of ownership is the key element of the alleged crime of enslavement. Moreover, Your Honors, according to the latest practice of the ICC, namely the case of Dominic Onwin, it is stated that factors that prove the exercise attaching to the rights of ownership is the existence of forced labor. Respectfully, Your Honors, now the defense will prove the absence of forced labor following 3 sub-arguments. Firstly, forced labor was impossible because of the voluntariness of labor. Secondly, the evidence that may prove in some way the involuntariness must be considered as inadmissible before this court. And lastly, Your Honors, in any event, the work performed by the revolvers must be considered as compulsory education, since we do not have to forget the educational centers were established at rehabilitating the revolvers. Turning to our first sub-argument, we submit that the work performed was voluntary. Your Honors, the indicators of the voluntariness of labor is the existence of certain advantages, such as skills that could be deployed by the detainees after their release. And in the case at hand, firstly, according to the case, we see that the prisoners voluntarily agreed to participate in the educational program. And moreover, they were taught different skills, such as metal work, that must have been deployed by them if taking into account for the public's economy. And hence, the voluntariness aspect is satisfied. Turning to our second sub-argument, we submit that the evidence that may prove the involuntariness is inadmissible before this court. Your Honors, the prosecutor alleged and indicated, I quote, that the work performed involuntarily and stated that there were various forms of coercion by taking the passports and moreover, by stating that the workers were isolated. However, what is the basis that was the evidence of such words? It is the NGO evidence and the statement of Hyeyoung. In this regard, we submit that the NGO evidence should be considered as inadmissible, since it can only provide the court with the background information regarding the crime. However, Your Honors, not the key elements. And moreover, this statement of Hyeyoung, who is one of the alleged leaders of the ANG movement, which is a separatist movement by its nature, also raises a question regarding its probative value, since it was indicated in the Hassan Sassi case that the subjective belief of the laborer that he was forced to work is not enough to establish the lack of consent, but must be supported by objective evidence. In this case, Your Honors, the case of Lord Blaze lacks any objective evidence, such as video or the photo stating and proving that the workers were undergoing work under bad and allegedly poor conditions. And there is only the aerial footage and the statement of one of the detainees, which are not corroborated, as stated by the Judge Seoane. I would like to quote that there is a kind of contradiction, Your Honors, in such statements. And it also raises a question regarding the probative value of such evidence. And respectfully, it should be considered as inadmissible. And before turning, Your Honors, to the third sub-argument before this court, the defense would like to also invite the court to the latest practice concerning the labor. Your Honors, the prosecutor stated that the workers were undergoing work under bad conditions, and even if taking the evidence, we submit that it is still not enough to amount to the conclusion that forced labor took place, even the working of 12 hours. And the case of Rowe versus Bristol is instructive here, since the workers in such case worked from 12 to 14 hours, and they were isolated since they were working on the plantation. However, the chamber found that the bad conditions do not amount to the conclusion that the consent was impossible and that there was forced labor. And this is helpful for us to consider that forced labor did not take place. But in any event,
excuse me, counsel, what is the authoritative source for this court applying this precedent that you are mentioning?
Your Honors, the case of Rowe versus Bristol is one of the cases that were considered by the District Court of Indiana in the USA. And it concerned also a work that was conducted for a private company, namely the Bridgestone, which is a famous tire company. And the chamber found that there was no forced labor. As I emphasized, the bad conditions do not amount to such conclusion. And
that, sorry, in relation to the Rome Statute, is there any kind of obligation or like a way of quoting or citing this precedent within the framework of the Rome Statute?
Your Honors, indeed, there is a possibility for this chamber to consider the practice of courts. And the Article 21 of the Rome Statute is instructive at hand, since it gives a possibility in the Article 21 1 clause C to apply, I quote, the general principles of law derived by the court from national laws of legal systems of the world. And at hand, we consider such law as it was applied by the District Court of Indiana of the USA, which is also a national law. And now, Your Honors, even if considering the evidence and such bad conditions, we still submit that the court should not forget that the education centers were established at rehabilitating boards, and the work performed by them must be considered as compulsory education. In this regard, we state that the labor was legal since it rehabilitated them. And for instance, the latest practice of modern world, such as in the USA, as well as in Japan, proves that the prison labor may take form if it is in aim of rehabilitating the person, providing him with skills that could be deployed by him. And the case at hand considering this. And hence, Your Honors, now considering all the above mentioned arguments, we submit that the material element is absent. Your Honors, moving to the second argument, we submit that the mental element is absent. Although the prosecution did not address such element, we submit that it is essential to address such element to prove the existence of subject matter jurisdiction, since all of the elements are cumulative and the absence of at least one excludes the existence of such subject matter jurisdiction. In the case at hand, there is no information, according to the case facts, that Zilla personally surveilled the detention centers, as alleged by the prosecutor, since they were education centers. And moreover, there is no information stating that Zilla exercised such powers as the Article 30 of the Rome Statute requires. In this respect, we submit that the all alleged elements are absent and the subject matter jurisdiction of the court is not satisfied.
Excuse me, counsel, but you are referring the knowledge in terms of the enslavement only, but in general, what was the knowledge of Lord Blaze in relation to the crimes against humanity? Because you didn't develop on the contextual elements, but there's a knowledge that there should be also referred to this point. And there was an anti-extremist, anti-terrorist order from the president, which would imply a kind of knowledge on the practices that then after succeed.
Your Honors, the defense addressed in the issue before this court the knowledge not of Lord Blaze, but the knowledge of Zilla, who is believed by the prosecution to be the initial perpetrator of the crime. And if even the defense would consider the contextual elements, it would also contest the knowledge of Zilla, since she is also believed by the prosecution to be the initial perpetrator of the attack at hand.
But in this particular case, this course is referring to the case of Lord Blaze. So in this particular case, we would like to know what the knowledge of Lord Blaze and what you can infer from the situation of the anti-extremist order and what happened then with enslavement.
Your Honor, the defense will submit the knowledge of Lord Blaze in the last argument before this court. However, answering briefly now, we submit that even the anti-extremism order does not amount to the conclusion that Lord Blaze knew about the crime, since he was only the president that I emphasize aimed at maintaining and establishing peace in the state of more than 25 ethnic groups. And respectfully now, the defense would like to move to the second issue before this court, considering the admissibility of the case at hand. And Your Honors, the defense will build its argument in the order that was addressed by the prosecution and prove that the bis in idem principle is violated, as firstly, Lord Blaze has been tried by the National Court of the Fire Republic. Secondly, the amnesty can be invoked before the court, and it is consistent with the international law. And thirdly, Lord Blaze was not shielded from criminal responsibility. Firstly, according to the Al-Gaddafi case, the judgment is not only a trial, but a trial that considers criminal proceedings. And such judgment indeed should have been based on the merits, as was alleged by the prosecution. And moreover, such judgment also should require the res judicata effect, which means a final decision. In the case at hand, Your Honors, firstly, the judgment was based on the merits. And in this regard, we would like to invite the court to the paragraph 17 of the case. And it is stated that the Truth and Reconciliation Commission was created just after the signing of the peace agreement. And it was created to establish truth. And respectfully, Your Honors, the judge should have considered such establishment of truth by indicating the formal investigation of such facts. And moreover, in the case clarifications, it is emphasized that the judgment was final. And another factor that proved the final of judging is that the judgment was stated by the Constitutional Court, which is usually believed to be the final institution. And that is not enough to appeal. And turning to our second argument, we submit that the international law does not prohibit the amnesty granted to Lord Blaze. And although the prosecution, I quote, stated that amnesty cannot be invoked due to customary law, unquote, we submit vice versa. And as an example, we would like to infer to the words of the famous professor of Charlotte, who stated that the practice of states does not yet, I quote, support the present existence of an obligation under customary international law to refrain from conferring amnesty for crimes against humanity, unquote. And gathering this and moreover the practice that was taken in Uganda, in Haiti, as well in South Africa, we submit that the international law does not prohibit the amnesty granted to our client. And turning to the second argument, turning to the third argument before this court, we submit that Lord Blaze was not shielded. And Your Honors, the indicators of the shielding was stated in the Machova versus Bulgaria case of the ACTHR. And it was stated that the indicating factor is that the evidence should be ignored by the court and all the important facts. However, in the case at hand, the evidence was established in February 2020. However, the court trial, according to the case facts, took place in the summer 2018, which means that it could not have physically refrained from any evidence presented to it. And considering this and all the above mentioned, the case at hand is inadmissible before the court. And Your Honor.
Counsel, a question in relation to this point about shielding the person from the justice. Is this court should consider the fact that the judicial control over the amnesty lasts 4 days? Is that enough to resolve about the merits that you mentioned?
Your Honors, the court at hand should always consider all facts presented to it, as well as the 4 days. However, we submit that the time does not amount to the effectiveness of the court, since it was the constitutional court of the Far Republic that must have been thoroughly accessing all the facts and evidence presented to it. And therefore, the case at hand is inadmissible. And in the interest of the time, now the defense will address the third issue before this court concerning the interest of justice that are violated. Your Honors, firstly, the interest of justice principle could be considered by this court. And although the prosecution maintained its position by stating vice versa, we submit that there is no precise article that states that the court is prohibited from reviewing the decision of the prosecution. It only states that it can review if the case was considered not serving the interest of justice, but there is no prohibition. Moreover, the practice of the ICC taking in various cases, such as in the case of Kenya, prove that the court could review the decision of the prosecution. And finally, Your Honors, the defense would like also to state that the court at hand should be considered as a crucial justice institution that should always consider whether or not the case would serve the interest of justice, just as in the case at hand. And finally, the case is violating the principle of interest of justice, since the interests of victims are not satisfied. And although the prosecution also stated that the victims were not considered, the case of Côte d'Ivoire is instructive, since in such case, the victims themselves indicated the desire for the justice to be done in the form of the prosecution of the alleged perpetrators. However, in such case, we lack any such information. Respectfully, the interest of justice principle is violated. Now, I would like to yield the floor to my co-counsel, who will address the final issue. May it please the court.
Good afternoon, Your Honors. May it please the court. My name is Dmytro Olefir, and on behalf of the defense, I will now demonstrate that Mr. Blaise is not criminally responsible for alleged crime of enslavement. We will reply to the three arguments raised by the prosecution. Hence, we will submit that there was no superior-subordinate relationships between Mr. Blaise and Ursa Azaila. Secondly, Mr. Blaise didn't know that Ms. Azaila was committing the alleged crime. And thirdly, Mr. Blaise didn't fail to take all necessary and reasonable measures within his power. Starting from our first argument, key elements of superior-subordinate relationships are effective authority and control. And since this requirement is cumulative, absence of one element excludes overall responsibility of the superior. Your Honor, in Bemba case, the effective control of the superior was defined as his material ability to punish, to prevent, repress, and submit the crimes of his subordinate to competent authorities. In case at hand, we submit that Mr. Blaise had merely distant control over Ursa Azaila. Although prosecution stated that Mr. Blaise could issue orders and ensure obedience, we draw court's attention to the fact that Ms. Azaila acted inconsistently with the order of Mr. Blaise, mainly with the executive order, by committing the alleged crime of enslavement that could not be considered as necessary means to end the potential threats to national security of the Fire Republic. It means that Ms. Azaila possessed certain level of independence. Additionally, in Kordich case, this rule was further developed, where trial chamber found that it is unnecessary to look just at formal titles. That is why court could not prove effective control of the superior solely relying on a formal position as president of Mr. Blaise. Moving to our second argument, that Mr. Blaise didn't know that Ms. Azaila was committing the alleged crime. Your Honors, in case at hand, no powers attaching to the rights of ownership were exercised regarding the people in education centers. Respectively, Mr. Blaise must have thought that detainees were repairing and building cars there and were studying there with purpose of efficient reintegrating into society. The prosecution in its submission stated that there was well-established reporting system. However, here we draw court's attention to the fact that there was only one report submitted by Ursa Azaila. And moreover, prosecution refers to the report without disclosing its content. Additionally, prosecution refers also to Exhibit 1 and 2, where Lord Blaise and Ursa Azaila had some discussions on matters in St. Tariq. However, we submit that plain reading of Exhibit 1 and 2 does not give any possibility to infer such knowledge on behalf of Mr. Blaise. Your Honors, there was mentioned mutiny. However, reasons of mutiny could be different. In case at hand, St. Tariq already accommodated 70,000 prisoners. That is why Mr. Blaise just cautioned Ursa Azaila that placing 40,000 more may cause mutiny due to overcrowded conditions. In fact, not due to conditions similar to enslavement. Also, Also, as I requested more minutes supply, and Exhibit 2 clarifies that it was steel, engine, glass, rubber. In our view, it once more proves that Earthborers were repairing and building cars there, which was within their professional activity. Moving to our third argument, Mr. Boyce didn't fail to take all necessary and reasonable measures within his power to prevent, repress, and submit the crimes of his subordinate to competent authorities. Your Honors, assessment of all necessary and reasonable measures must be based on considerations of what powers was at disposal of Mr. Boyce, and it must be based on considerations regarding knowledge of Mr. Boyce. In case at hand, Mr. Boyce was not supposed to prevent as well as repress the alleged crime, since he had no knowledge about it. Nevertheless, he submitted the alleged crime to the competent authorities. Your Honors, thus, we submit that Mr. Boyce didn't fail to take all necessary and reasonable measures. Therefore, Mr. Boyce is not criminally responsible for alleged crime of enslavement. And for the above stated reasons, and those stated by my co-agents, we would like to respectfully request this court to decide this case in favor of arguments established on behalf of the defense counsel. Finally, it was referring to the principle that should not be forgotten. For justice to have any meaning, it must also mean that no innocent person could ever be executed. Your Honors, thank you for attention, and may it please the court.
Thank you very much, counsel. And we now have an opportunity to hear the rebuttal. And may I ask the prosecution to present the rebuttal?
Good afternoon again, Mr. President, Your Honors, and may it please the court. In rebuttal, the prosecution submits 3 points. The first being on the inadmissibility of the evidence, namely the statement of Hyeyoung. Second, on the involuntary nature in dissenters, and finally on the status of the victims and in the peace process. Regarding the first point, the defense stated that the evidence should be inadmissible, and that Hyeyoung's statement should be inadmissible. However, according to Article 69(4), the court may rule on any evidence, and they will assess the probative value and the prejudice of that evidence. And only if, in accordance with Article 67, the evidence is contrary to international recognized human rights, if it is acquired contrary to this, should it be inadmissible. However, in this case, all the evidence is acquired not in any means contrary to internationally recognized human rights, and should therefore be considered admissible. Regarding the probative value of Hyeyoung's statement, the defense stated that Hyeyoung's statement is not sufficient to prove the element of coercion, as there are discrepancies within his statement. However, in the oral trial judgment, it was stated that the testimony of a single witness on a material fact as a matter of law, does not require corroboration. And furthermore, in the same judgment, it was stated that minor discrepancies between the evidence of different witnesses do not discredit their evidence. In this case, the minor discrepancy, as Lord Blaise stated on the automobile company and another evidence, is not sufficient to discredit Lord Blaise's statement. Therefore, this piece of evidence does reach the probative value necessary in this case. Turning to the second point on the involuntary nature of the work, the defense stated that the work was done involuntary, and the conditions in the nature do not discredit this involuntariness. They used a domestic case law, an Indiana case, to state that the detainees worked 12 to 14 hours and were isolated, and this did not constitute forced labor. However, Your Honor, in Kroniak, which is a ICTY case, which has higher value according to Article 21, in accordance with Article 21(1)b, the court shall assess rules of international law, and this case can be used to interpret international law. And domestic cases only come after this in Article 21, 1c. And in Kronerlock, the detainees only worked 5 days a week. And in this case, forced labor was established as the conditions of the prison in this case were so coercive to negate any possibility of consent. Therefore, we also believe that the conditions in Center Rig were also of such a coercive nature to negate all consent given by the detainees based on Hyeyoung's statement and the fact of detention and the overall coercion they face within this detention center. Turning to the final point, the defense misinterpreted the law as requiring the prosecutor to prove that the victims support prosecution. However, Your Honors, in accordance with Article 53(3)b, the chamber shall only review a decision of the prosecutor not to proceed, meaning this is a negative test. There needs to be a clear indication that the victims oppose prosecution in this case, and the defense would need to prove this. However, in this case, the defense failed to prove a clear indication of the victims that they oppose prosecution. In this case, we do not believe that the victims oppose prosecution, and therefore the case does fall within the interests of justice. To conclude, the case is in the jurisdiction of the court, as the consent was not rendered irrelevant and the evidence is admissible. And finally, the case is in the interest of justice, as the victims, there is no indication that the victims oppose this. This concludes the submission of the prosecution. Thank you very much.
Thank you very much, counsel. And the defense may present their rebuttal.
Mr. President, Your Honors, and may it please the court. The defense will now respond to the three arguments raised by the prosecution and its rebuttal. With respect to the first point, we still emphasize that the evidence is
I cannot hear, sorry.
A little bit louder.
Mr. President, Your Honors, and may it please the court. The defense will now
Sorry, Your Honors, do you hear me now?
Yeah.
Mr. President, Your Honors, and may it please the court. The defense will now respond to the three arguments raised by the prosecution in its rebuttal. With respect to the first point, we submit still that the evidence presented by this court is inadmissible. Your Honors, firstly, since the NGO is not the part of the prosecutor's office, they might make mistakes in interviewing the person. For instance, all the evidence maintained by the prosecution while submitting is derived from the NGO evidence. Secondly, Your Honors, as the neutrality of the GHR, which is the NGO, cannot be verified, we also submit that it is not admissible at hand. And thirdly, according to the Katanga case, the statement of the alleged workers are not sufficient for the court when considering, since they could be biased if it's only one evidence. And the case at hand considers only one statement of Hyeyoung. And finally, Your Honors, although the prosecution relied by saying that the mere corroboration is not necessary for the court at hand, we still submit that even the ICC itself maintained in the Ruto-Koshay case that the evidence should not be controversial. However, the evidence at hand is controversial, since we see that the aerial footage does not prove the words of Hyeyoung, since there are no poor working conditions by it. And considering this, we submit that the NGO evidence and the statement is inadmissible before this court. Turning to the second argument, we submit that the wantonness aspect is still satisfied. Your Honors, indeed, the court is not bounded by the judgment of any court. However, it should consider it. But in any way, the defense would like also to invite the court to the latest practice that takes place in modern world. For instance, in Texas, there are existing various prison and prison labor, ranging from working for private companies, and the workers there work from 12 hours a day. Moreover, the workers do not receive any salary, just as in our case. And finally, Your Honors, in Texas, the prisoners' work is still considered to be legal in modern day, since it does not only cut their prison term, but it rehabilitates them into the society. And thirdly, Your Honors, now the defense will maintain its position by submitting that the interests of victims are still violated under the scope of interest of justice. Your Honors, the case which was cited before by the defense is instructive, which took place in Côte d'Ivoire. However, the defense could also invite the court to another practice that concerned place in the Uganda. For instance, in such situation, the ICC itself, unfortunately, did not sufficiently take the interest of victims, and subsequently, the peace agreement and settlement process was violated, since the amnesty law was not sufficient to end its term, since the interests of victims were not taken into account as they supported the amnesty. However, the ICC still relied on granting the warrant of arrest on the main leaders of the alleged crime in such situation. And mentioning all the above stated, we would like to emphasize that firstly, the evidence is inadmissible. Secondly, wantonness aspect is satisfied. And thirdly, the interests of victims are violated. Your Honors, thank you for your attention, and may it please the court.
Thank you very much, counsel. And the court will now adjourn.
I will now send the judges into the deliberation room and the team members into separate breakout sessions.
Good afternoon, everybody again. And we came back with our decision. And before I will announce our decision, I would like to firstly to congratulate both teams with a very interesting presentation of their positions. And we will share with you some short feedback, and then we will announce our decision. And Dalila, may I ask you to speak on behalf of the bench?
Thanks. Well, as I make echo of the words of my colleague, of course, like congratulate you because you are here. This is like a quarterfinal, so you have done like a good job coming here, and we really appreciate your efforts and the work that we can see. I will briefly mention some comments. General, of course, as you know, we cannot go into substantive matters. In relation to the prosecution, what I would suggest for the future is try to see the camera. For example, I like the fact that you stand up and you talk like more in a court way. So it's like a nice thing, but try to see the camera, try to see the place of the camera, because sometimes it's good for the judges make visual contact. And I find that this is like something good also to have into consideration. Then in general, as you can see, we were an active bench, so making questions. So be prepared that if you're planning to code something in terms of substantive law, have the source and this is something that maybe you can mention in advance, so you don't have to explain, or you don't have to wait the question from the judge saying that what is the source for this or something like that. So this would be something that you can include in your speech, for example. So in terms of the substantive matters, of course, I mean, no one mentioned this, but yeah, there's more things that you can develop on some points. In relation to the time management, I think that you did it very well. Don't be afraid about the speech, because we know that we made questions. So at some point, if you are like maybe jumping one point in your points that you have, we don't know what are the points that you are planning to develop. So don't get nervous and keep moving, because it's fine. In relation to the defense, as the defense is good to try to discuss all the elements, and it's important, for example, that you consider the crimes, international crimes, in both aspects. So this is something that you can also develop more in detail. And also to have into consideration the procedural argument. This is something really important for the defense. Try to contest procedural arguments that you can find in the case. And the other thing is that, for example, the sound went much better when you remove the headphones and you start speaking directly with the computer, I guess. So have that in mind too. So thanks again, congratulations. And I give the floor to the presiding judge.
Thank you very much, Dalila, for your comments. And again, both teams did great job. But again, it was necessary to decide in favor of one of the team. And we decided in favor of the prosecution team. Our congratulations to this team, and again, in any case, our congratulations to the defense team. Thank you very much to both teams, and to our bench clerk and to my colleagues. And this concludes our sessions.
Thank you for your comments. Congratulations to the team number 40.
Congratulations.
Yeah, congratulations.
Thank you.
Congratulations.
Thank you very much.